Thanks, Diane. Hi, everybody. It's awesome to see so many friends, even if it's virtually, to see your name and know you're out there. I'm excited about today's topic and to present. I am maybe most excited to have Brad Pack joining me. His presence definitely raises the mean intelligence and legal skill level of the presenters today. So I appreciate having him with us. And we recognize that a lot of you out there interact with debt collection, debt defense, consumers in many different ways. And our goal today will be to, hopefully at least give some direction and some information. A lot of you maybe came today hoping to get clarity around Proposition 209 and its impact, and unfortunately, some of what we'll present today will not clarify and provide bright line rules because they don't exist yet. But we will at least make you informed and competent around advising your clients. So I want to take 30 seconds to introduce myself, then let Brad introduce himself. Then I'll give a quick overview of the agenda and we'll jump right in. So I know a lot of you know me, but for those that don't, I have a primarily consumer bankruptcy firm here in Arizona. Our main office is in Chandler. We also do other debt-related work such as student loan debt work. We do tax problem debt work, debt settlement work. And what I'm most excited about right now, really, in my practice, is the developments that have happened in student loans. And so if any of you do represent student loan borrowers in any capacity and or interact with student loan borrowers, please feel free to reach out to me. I'd love to chat with you about just some of the exciting things that are happening in student loans. And that's a little bit about me. Brad, why don't you introduce yourself?
Well, so first of all, Ken, thank you for that very nice introduction, probably much nicer than I deserve. But my name is Bradley Pack. I am a partner with the law firm of Engelman Berger. My practice is primarily bankruptcy, litigation, and appeals. So in the bankruptcy arena, kind of in contrast to Ken, we represent everybody except for consumer debtors in bankruptcy cases. So we represent debtors in business cases, and we also represent creditors in a lot of bankruptcy cases. Outside of the bankruptcy arena, I do a fair amount of civil litigation, including post-judgment collections work. And I think I mentioned I do civil and bankruptcy appeals. So I'm very excited to be with you here today. I think this is this will be an interesting area of law, seeing how Prop 209 plays out, and perhaps at some point litigating some of the potential ambiguities in the statute. So with that, I'll let Ken take over from here.
Thanks, Brad. Yeah, so Brad and I end up representing adverse parties a lot, and he's a consummate professional always. So, all right, let's do a quick overview of the agenda. So we're gonna discuss what's in Prop 209, right? What is it? What's in there? We won't spend a lot of time there because a lot of you probably already know that, but we'll hit the important points just so that you kind of understand what it is, what at least the text of the Arizona revised statutes looks like now. The effect of that remains to be seen, but what the text looks like, we'll talk about. Then we'll talk about a current lawsuit that's ongoing, filed by some plaintiffs to try to enjoin the law. It's the Arizona Creditors Bar Association, and I think some other plaintiffs seeking to enjoin it. We'll give you a quick status on that. It's interesting to note and probably important to at least be aware that it's out there. And then Brad's going to talk about the effect of Prop 209 and the new laws on state court collections matters and some of the open questions around that, and pose a hypothetical. And then I will talk about the effect of Prop 209 on bankruptcy cases and some of the open questions there. We'll show you some cases that might guide how things will go here. Those are also in the materials, a few of the cases we have found. And throughout, we will be glad to take questions. The best way probably to do that is to just post it into the chat, and we'll take them as it makes sense to take them. We reserve the right to ask you to turn on your camera and ask your question in person if we think it'll be interesting to add to the discussion. So be prepared to do that if you ask a question that we may want you to just get on and state it. So with that being said, let me advance the slide here, and we will see what's in Prop 209. So it wasn't just medical debt. Okay, so that's how it was marketed, and that's kind of what a lot of people I talked to who voted for it thought it was just limited to a percentage cap on medical debt. But there was a lot more in this proposition. It increased many of our exemptions. Homestead went from 250,000 to 400,000. Plus inflation. I'll explain what that means in a second. Motor vehicles went from 6,000 to 15. A disabled debtor with a motor vehicle exemption went from 12,000 to 25,000. Household goods from 6 to 15. Bank account from $300 to $5,000. I calculated what percent increase that was at some point. I don't remember what it was, but it was hundreds and hundreds of percent, if not thousands of percent. So big increase there. And then wages subject to garnishment or the protection of wages not subject to garnishment increased from 75% to 90%. And the amount subject to garnishment is only applicable now for disposable earnings above 60 times the applicable minimum wage, as opposed to the prior law was 30 times disposable earnings. So what you're looking at there, the effect of that is that if you have a judgment debtor or a bankruptcy debtor to some degree, earned but unpaid wages in bankruptcy, what you're looking at for a judgment debtor in state court that might be subject to wage garnishment is disposable earnings of over 43,000 a year, which is more than 43,000 of gross earnings because there are certain allowed deductions under the statute. So that's just to be able to garnish a penny, right? So once the judgment debtor goes over 43,212 of disposable earnings, then you can garnish a penny, but you can't garnish the full 10% until there's 10% available above that. So it kind of will slide up where you would not be able to garnish a full 10% until that judgment debtor was probably around 50,000. I think it's like 49,000 of disposable earnings. So much more than that in gross earnings. Well, not much more, but somewhat more than that in gross earnings because of the allowed deduction. So you're looking at a lot of current judgment debtors that are subject or were subject to wage garnishment that will no longer potentially be subject to wage garnishment and subject to these open questions that we will be discussing. So those are the exemption changes. The plus inflation, what that means is that every year on January 1st, starting in 2024, so starting in just under 1 year from today, those exemptions will increase if the inflation index, and there's a formula for this. I think it's measured as of August 1st of the prior year. So August 1st of this year, we'll look at that index, and then that will be applied to the exemptions that go into effect a few months later on January 1st of 2024. So as we've seen with our minimum wage, which is now $13.85, by the way, if you can believe it, when something is tied to inflation, and we're in an inflationary environment, those exemptions can increase quite quickly, which is what's happening with our minimum wage. So those are the exemptions. The limits on interest, this is, the main thing that was marketed was the medical interest cap of 3% or the lesser of 3% or 1 year constant maturity treasury yield. And then the other interest cap is on non-medical debt. It's either the contracted rate, so they're not taking away the contracted rate, but they are saying if there is no contracted rate, then the judgment interest is capped at the lesser of 10% or prime rate of interest plus 1%. Okay, so which in many circumstances could be less than 10%. All right, so that's what's in it. A lot more than I think a lot of people knew. And now what's going on with this law? Well, it became effective on December 5th of last year, 2022, about a little over a month ago. Interestingly, though, in the act, there is a saving clause, is what they call it, a saving clause, in section 9 of the act, and the act is in your materials, so you can go find this section, but this is the exact text from the saving clause. It says this act applies prospectively only. Accordingly, it does not affect rights and duties that matured before the effective date of this act, contracts entered into before the effective date of this act, or the interest rate on judgments that are based on a written agreement entered into before the effective date of this act. Okay, it seems relatively clear when you first read it, but as you start to think about what does matured mean, when does something exactly mature, they don't define it. Under what standard are we talking about maturing? It doesn't really deal in a great way with non-contractual types of debts, and so it's a bit vague. And importantly, as we will discuss later after Brad's portion, and Brad might touch on this too, but importantly, it's not codified. It's in the act, but it's not in ARS, the saving clause. Okay, so the saving clause, I think, was intended, I haven't talked to the drafter of this act or the saving clause, but I think was intended to cut off potentially a constitutional challenge or something, to where a creditor might come and say, well, you're taking away some of my rights, and we had this right to contract and we did it, and now you're taking away some of my rights that were agreed to between me and a debtor, and you can't do that. And so the saving clause, I think, is my speculation, but I think was intended to allow a court to say, oh no, you're not losing any rights, because the saving clause says if you already have that contract, then it doesn't apply.
We had a question that maybe goes to that question of intent. What was this intended to do? Which was, who are the folks that were behind this act and who put the money behind it? My understanding is that it was the Service Employees International Union that was the primary contributor to the campaign and the primary driving focus of this. Not sure entirely why it would be the SEIU that has such an interest in it, but obviously they represent workers, and it would be in the best interest of workers, arguably, to have limits on how much interest they have to pay on their healthcare debt. The exemption, all of the exemption things, which I think could have much more significant impact. I don't really quite know why the SEIU is so interested in that, but that is my understanding of who's behind this act.
The feeling from some of these creditors associations, such as the Arizona Creditors Bar Association, certain people over there, is just that it's the SEIU flexing its muscle in Arizona as it's seeking to unionize some to increase unionization in some of our companies here in Arizona. That's the feeling. This is just I don't think that's in writing anywhere, but that they spent a lot of money, $7 to $8 million, to get the bill passed, and there must be a long game, which is possibly to try to increase unionization here in Arizona. And this just shows that, hey, we can change laws if we want to change laws. And they got a 72% passage rate on this, which was the second highest vote total passing a proposition in our last election. The only other one that beat it only was 0.1% higher. So this was the highest passing thing on the ballot in Arizona in November, or very close to the highest passing question on the ballot. So
yeah. I'll tell you what I found interesting about the campaign too, is that there seemed to be very little organized opposition to the ballot proposition. Because I read the pamphlet, I saw the Arizona Bankers Association was opposed to it, and there were, I think, maybe some of the chambers of commerce opposed it, but I only saw advertising in support of Prop 209. I saw zero opposed to Prop 209. So unless you actually read that publicity pamphlet, which has to be like less than 1% of voters, maybe I'm overstating it, but I mean, there was like, this really kind of flew under the radar, and I think most people would just read the headline, read this is a cap on healthcare interest and not look any further than that. So I think
Exactly.
this, well, it did get a ton of support. It really kind of flew under the radar a bit too.
Yeah. Yeah, absolutely. I just got confirmation from a private message that is really the intent of the law is by this union to kind of start to make inroads to unionize here in Arizona. So, all right. So let's look at this really quickly. Just an update on this suit to enjoin Prop 209 filed by the Arizona Creditors Bar Association. This is the case number at the trial court level. It's now at the appeals court level, but what the Arizona Creditors Bar Association claimed was unconstitutional vagueness. Other claims too. It was a very well drafted complaint. You can go read that. I did include in the materials the order denying the injunction so that you can kind of see what the trial court felt about those claims. But as we go through this program, you'll see some of the questions, big questions that were created. And so the concern, obviously, by the Creditors Bar Association is just how do we run our law firms and advise our clients and proceed without stepping on violating laws, but still being effective in what we do to collect debt. So the results so far, well, I mentioned the trial court denied. There was a temporary injunction, but that was ultimately lifted. The plaintiff sought a direct appeal to the Supreme Court. The Supreme Court did not accept it, so it's in the Intermediate Appeals Court, and it's on a standard briefing schedule, is my understanding. So it's a few months out until even really anything starts happening. And by then, people are going to be muddling their way through this in state, are going to have to be muddling their way through this in state court. And, maybe some consistency will start to emerge, or maybe not. It'll be interesting to kind of see what happens in the meantime, and then it'll be interesting to see even if the appeals court really does much with it, or just says, we're going to just let it sort itself out in the trial courts and coming up through the appeals courts. So, all right, current status. Yeah, we got that. All right. So I'm going to hand it over now to Brad. He'll spend some time discussing the state court collections actions, and then we'll transition over to bankruptcy. Take it away, Brad.
Yeah, okay. So there's a couple of things that I want to do, actually. First, just give a general overview of the state court collection process, which if you practice exclusively in bankruptcy, you may not be entirely familiar with it. If you represent debtors in state court, then certainly you will. And I'm just telling you what you already know. But I think it helps to kind of put some of this in context and talk about where these issues about the what I think are some of the serious ambiguities about the savings clause might be raised. So in general, once you have a judgment, one of the first things that most creditors will do is record that judgment along with a judgment creditor with a judgment debtor information statement, which will then create a lien on any real property that the debtor owns in the county in which it's recorded, except for homestead property, to the extent the homestead property has equity less than the exempt amount. So it's kind of confusing. There was a lot of confusion and a lot of conflicting opinions as to whether the recording of a judgment would create a judgment lien on homestead property. That was kind of resolved through an amendment to the law that became effective at the beginning of last year. But that is one of the first steps generally that creditors will take. But that often doesn't pay off until much later in the future, when the judgment debtor tries to refinance or sell that property and needs to actually get that lien taken care of. When a creditor wants to collect immediately on its judgment, usually there's two avenues that the creditor will take. Either they'll serve a writ of garnishment, or they'll have the sheriff serve a writ of execution. On garnishment, there's generally two types. There is a earnings garnishment and a non-earnings garnishment. So an earnings garnishment is directed to the judgment debtor's employer, and it requires the employer to withhold the non-exempt amount of wages for each pay period from the debtor's paycheck. Wages is defined very broadly for purposes of the statute, so it's not just base wages, it includes commissions, bonuses, really very broadly any type of payment that you're getting on account of services for the work that you do is considered wages or earnings within the meaning of the statute. A non-wage garnishment is directed to somebody who is in possession of the judgment debtor's property or somebody who owes money to the judgment debtor. Usually, writs of non-earnings garnishments are directed to bank accounts, but you can really garnish anybody who owes money to the debtor. So you can, if the debtor has tenants, you can garnish their tenants so you get their rent payments. If the judgment debtor is the holder of a promissory note and somebody owes money on that note, you can garnish the person who owes the payments on that note. Or if somebody is in possession of personal property of the judgment debtor, you can serve a writ of garnishment on them, which will then require them to hold on to that personal property until the sheriff can come and seize it and sell it. You can also garnish any corporate stock that the judgment debtor is holding by garnishing the corporation. The procedure for both types of garnishments is somewhat similar, although the earnings garnishment statute is actually, there's a lot more to do. There's a lot more process when you're garnishing somebody's employer. But in general, in both cases, you first have to have the clerk issue a writ of garnishment, which is pretty easy because just it's a form. You take it down to the court. The clerk will just stamp your form. And then you serve the writ of garnishment on whoever it's directed to. If it's an earnings garnishment, you serve it on the judgment debtor's employer. If it's a bank garnishment, you serve it on a branch of the bank where the account is located. And then the garnishee, the person to whom the writ of garnishment is directed, has to file an answer within, I believe it's 10 days after being served, 10 business days. I could be wrong, but it's not a huge period of time. After the answer is filed, both parties, the judgment creditor and the judgment debtor, have the opportunity to raise objections to the writ of garnishment. And this is generally where you are going to see the objections being raised that implicate Prop 209, because it's in the objection to the writ of garnishment that you would argue that the money that's being withheld is exempt. In fact, the judgment creditor also has the opportunity to object to it too, because on the answer form that the garnishee files, they have to indicate whether they're not withholding any money because some of it is exempt. So if the garnishee says, hey, if it's a bank account, for example, and the garnishee says there's $10,000 in this bank account, we're only withholding $5,000 because the new exemption amount is $5,000, the judgment creditor can object to the garnishee's answer. If the bank account, if the bank says, well, we're withholding $9,400 because only $600 is exempt, then the judgment debtor can object to that answer. In state court in Maricopa County, at least, most of these issues are decided by court commissioners. So they don't go to a judge, they go to a court commissioner who is essentially they're like the equivalent of a magistrate judge in district court. But for all intents and purposes, their rulings have the same effect as any other state court judge. So that commissioner will then rule on the objection, and the commissioner will be the one who determines the exemption amount and whether it's the new exemption amount under Prop 209 that applies, or the old one. And then once they've made that determination and they've ruled on any other objections to the garnishment, then they will issue a judgment. If it's a judgment, a judgment on a non-earnings writ, like a bank account, then the bank will just be ordered to turn over the money, or whoever owes the money to the judgment debtor will be ordered to pay it over to the creditor. If it's an earnings garnishment, then the court will enter an order of continuing lien, which directs the employer to withhold the percentage of non-exempt earnings from the debtor's paycheck every pay period. There was one other issue that I'm not quite sure we touched on yet, which is even with the lower, both before Prop 209 and after Prop 209, the judgment debtor can ask for an even further reduction in the amount of wages that can be withheld. So prior to Prop 209, it was 25% of wages were non-exempt. But if the debtor could prove to the court that it would be an extreme economic hardship to withhold the full 25%, they could get a reduction in the amount of their wages being withheld, so that only 15% would be non-exempt. In other words, they get to keep 85% of their disposable earnings. And that's really, that disposable earnings is their take-home pay. So after all taxes and other withholdings are taken out of their paycheck. Now, under Prop 209, the exempt amount, or 90% of wages, are exempt. So there's only 10% that's non-exempt. But the debtor can still get a reduction in that from 10% to 5% if they can prove that there's an extreme economic hardship. I will tell you, I haven't really dealt with those types of issues in front of a court commissioner. My understanding was they were pretty liberal in granting those reductions from 25% to 15%. I think now that the exemption amounts are so much greater, you're probably going to see much stricter readings of what constitutes an extreme economic hardship, just because it should be harder to prove that withholding 10% of your wages is an extreme economic hardship, more so than withholding 25% of your wages. So I think you're going to see a lot less liberality in that, and the standards for proving extreme economic hardship are going to go up.
Brad, I have a good question here from Corey Viola at Jaberg Wilk regarding non-earnings garnishment. I asked her to just turn on her microphone and ask it. Is this a good time for her to ask that?
Sure.
Okay, go ahead, Corey.
Hi, sure. So my question was about exemptions under non-earnings garnishments. So previously I have served a non-earnings garnishment on an obligor that made payments to my debtor in the amount of about 20 grand a month. I was able to attach to those. Now with the increased exemptions, I'm wondering, since this was not a bank garnishment, if the exemptions, or if anyone has any indication if those exemptions will apply to garnishments that do not freeze bank accounts, but otherwise seek to collect debts owed to debtors.
So I think the answer to that may turn on a couple of things. One is is the judgment based on a breach of contract action or something else? And then two, do you already have a judgment on the garnishment? Because, and we'll get to this when I talk about the hypotheticals, but the savings statute, the savings clause of this is drafted very ambiguously. It says that Prop 209 will not affect the rights and duties that matured before the effective date of the act, contracts entered into before the effective date of the act, or the interest rate on judgments based on a written agreement entered into before the effective date of the act. So there are so many stages of the process where you can say either Prop 209 does apply or it doesn't apply. First, if it's a contract action, you could argue, well, because my contract was entered into before December 5th, 2022, when Prop 205 took effect, none of the new exemptions apply. It's only the old exemptions apply now and forever after. I could see there being an argument that, well, the only intention here was that contracts entered into, the proposition not applying to contracts entered into before the effective date of the act, that really only applied to healthcare contracts. It doesn't apply to judgments that are based on other contracts. And where that is going to go, I think really remains to be seen. As a creditor's attorney, if I'm representing the creditor, I'm certainly going to argue, no, this says contracts entered into before the effective date of the act. That means any contract. If they wanted to say this doesn't apply to healthcare contracts entered into before the act became effective, they could have done that, and they didn't. But then let's say you don't have a contract action. Let's say your cause of action is based on I don't know, a tort, a negligence or something. Then the question becomes, when did the rights and duties of the parties mature? Did they mature when the cause of action accrued? Did they mature when a judgment was entered? In the case of a non-earnings garnishment, did they mature when the writ of garnishment is issued by the clerk? When the garnishee is served with the writ of garnishment? When the garnishee serves their answer? When the court has ruled on any objections and finally entered a judgment on the garnishment? I don't think there's really been any litigation yet as to what that part of the statute means, when rights and duties mature. And I think that's where you're going to see a lot of the litigation. So in your case, Corey, I think the answer is the very standard lawyer answer. It depends. I mean, there's a lot of arguments you could make one way or the other, but how a court might come out on it really remains to be seen.
Sure. So I guess my question is more geared to, do the exemptions apply to non-bank debt? So in my case, I had a judgment against a debtor. The debtor was owed 20 grand a month pursuant to a promissory note. I was able to attach to those payments. Nothing was withheld even under the old statute. Now it seems like the exemptions are tailored specifically to bank accounts rather than any other indebtedness. And I'm wondering, is that an issue that people are litigating, or is your answer the same since I've clarified? Are those types of debts also going to be exempt under Prop 209? Well, I'm assuming the contract was entered into after the date the proposition was passed for purposes of this hypothetical.
Yeah, so I actually don't read any of the exemptions themselves as having been changed. It's just the amount of the exemptions that has changed. And there may be some other exemption that applies if you've got a very creative debtor. And in litigating with Ken over the years, I found that he can be very creative, and so can many of the other fine attorneys who are members of ACBC. So maybe there's some other thing that they can pigeonhole it into, but I don't think this changes anything with respect to the types of property that are exempt. So, for example, if it's payments on a promissory note, in your case, I don't really see any exemption that would apply in that case, and it wouldn't matter whether Prop 209 applies or doesn't apply.
Yeah, I would agree with that too. Brad, Jim Kahn wonders if the creditor has due diligence duties to investigate the amount of earnings before applying for the writ of garnishment. What are your thoughts on that?
My thought is no. I've never seen a judgment debtor say, well, you should be sanctioned because I'm working a minimum wage job and I'm working less than 60 hours a week. I don't think there's any way you really can know that. Well, I suppose you could. I mean, you could take a judgment debtor examination and ask, but no, I don't think there's a duty of due diligence to investigate whether the judgment debtor's wages exceed that minimum threshold before you serve the writ of garnishment. On non-earnings garnishments, you are required, there is a due diligence requirement to at least know, to have some good faith reason to believe that the garnishee owes money to the judgment debtor or is holding property of the judgment debtor. You can't, for example, get a judgment against a client and you don't know where they bank, but you know there's 10 major banks that have a presence in Arizona. So you're going to serve a writ of garnishment on all 10 of them. That might not fly under the statute, is having a good faith belief that they're going to be holding some property of the judgment debtor that could be subject to garnishment.
Perfect. All right, you ready for your hypothetical now? On the next
Yeah,
slide.
I will say real quickly before we get into the hypothetical, and we kind of already touched on it, and I want to leave time for Ken to talk about the bankruptcy issues. But the other form of judgment collection process that's issued is writ of execution. And that's when the sheriff is directed to go out and seize and sell specific property of the judgment debtor. So either personal property that they own that's not exempt, or real property that they can levy on, and then they'll sell it at a sheriff's sale, which is essentially a public auction. And people do come and bid at those auctions, and the judgment creditor does have the right to credit bid. And there are specific procedures that apply in the case of sheriff sales of a judgment debtor's homestead. And in those cases, the sheriff is not allowed to complete the sale of the property unless there is a bid in excess of the exemption amount, plus the amount of any consensual liens on the property that have a greater priority than the judgment creditor's judgment. So under this new scenario, if Prop 209 applies and you've got a judgment debtor who's got maybe $450,000 of equity in their home, but they've got a $400,000 homestead, and they've got a $75,000 first mortgage on the property, the sheriff, unless somebody comes in and makes a really irrational bid and is willing to pay $1 million to buy the property, the sheriff's not even going to be allowed to accept a bid because the bid isn't great enough. It doesn't exceed the exemption amount plus the consensual liens on the property. So that's an important statutory procedure to take in mind when you are determining as a judgment creditor, do I go out and bother trying to have the sheriff sell this property at a sheriff's sale? Or if you're a judgment debtor, hey, can I object to this sale on the basis that there's no way that they're going to get enough money to actually be able to complete the sale? So that's what I wanted to talk about in terms of execution. If we can go quickly to that hypothetical slide, I think we already talked about this a little bit, but this is just a slide to kind of give some examples of all the parts of the process where you may argue that Prop 209 doesn't apply here because our rights matured before the statute became effective on December 5, 22, or they matured afterwards. So in this hypothetical, you've got a debtor who enters into a personal guarantee of the business's lease on June 1, 2020. The business and the debtor default. The creditor gets a judgment on June 1st, 2022. On November 1, 2022, the clerk issues a writ of general execution. The sheriff levies it against the debtor's homestead on January 15th, 23, and the sale is set for March 15th of 23. So under that scenario, there's lots of ways that you could argue either Prop 209 does or doesn't apply. You've got a contract that's entered into before the effective date of the proposition. You've got a judgment that's entered before the effective date of the proposition. The writ of execution is actually issued by the clerk before the effective date, but the sheriff hasn't actually gone out and levied on the property until after the effective date, and the sale isn't set to occur until after the effective date. So I think you can make arguments on either side that either the statute applies and the homestead exemption is 400,000, or it doesn't, and you're subject to the old $250,000 exemption. And it will be interesting to see how the courts come out on it. It'll be interesting to see what arguments people make for and against. So I'm kind of excited to see how that litigation turns out. And maybe that tells you something about the state of my life, that's what I find exciting. But that's just me.
Awesome. Thanks, Brad. Good stuff. So we'll transition over, and again, as Diane mentioned at the top, anyone that has questions, that you want to get into more detail, Brad and I can both stay for a little bit afterwards. All of you are not required to do that, but we can have some question time at the end. All right, so let's look at some of the questions that come up when applying these new laws in bankruptcy proceedings. So super quick overview of how bankruptcy exemptions operate. For those of you that don't do a lot of bankruptcy exemptions, very similar to and in the past in Arizona have just been identical to the same exemptions that apply to collections matters. Sometimes they operate a little differently, they're applied a little differently because the bankruptcy is sort of a snapshot in time, and there's even a rule called the snapshot rule where we determine the exemptions as of the day of the filing of the bankruptcy. And so you're not as concerned about maybe ongoing wages because the post bankruptcy earnings, at least in Chapter 7, are not subject anymore to the claims of creditors, but you would be looking at the earnings that were due on the date of the bankruptcy petition being filed. So sometimes they operate slightly differently, but historically have been the same exemptions in bankruptcy outside, at least in Arizona, in bankruptcy outside of bankruptcy. And that could change with this, as we'll discuss here in a minute. I think there are two big issues that need to be decided. There may be more, and it may be that I misidentify even these two. I don't know, but based on my conversations with many attorneys smarter than me, I think that really two things have to be decided at some point for us as consumer debtor bankruptcy attorneys to know exactly which exemptions apply before we file a case. And those two questions are, does the saving provision, even because it's uncodified, does it even apply in bankruptcy at all? And there is a case in your materials from Ohio. The name of the case is In Re Middleton. I'm going to pull it up on my screen here and give just a couple of the key points from Middleton, but read it if you practice consumer bankruptcy law at all, if on either side, if you're a debtor's attorney or creditor's attorney, because this will be important to kind of understand how this court, at least in Ohio, it's In Re Kyle. I misidentified the case. So it's In Re Kyle. The Middleton case I'm going to talk about in a second. So In Re Kyle is the Ohio case. In Ohio, a very similar change to the exemptions occurred, where in the legislative, in the language that was actually passed by the legislature in Ohio, it mentioned it had a date for when for debt to which these new exemptions would apply. Okay, so I stated that in a kind of confusing way, but basically not in the statute itself that was being passed, but in the act. They didn't call it an act, they called it something different in Ohio, but effectively it was in the act. It had a provision just like Prop 209 does that said this only applies to debts. Let's see if I can find the language. I'm not sure I highlighted the exact language, but it was very, very similar. It said, it just mentions here, at least the part I highlighted, uncodified language, giving an effective date to when these exemptions would apply based on the date of the debt. Okay. Now, the Ohio court went through a very detailed analysis that there's certainly not time to go through all of that right now in this plea. but go read it, because what it boils down to is when you have debts that under bankruptcy law should be in the same class, right? You have just two general unsecured creditors in a bankruptcy case, but the difference between those two general unsecured creditors is only the date of when the debt was incurred. Bankruptcy law sees no difference between those two creditors necessarily. And when a state law is passed that creates a distinction between those two creditors to where one creditor would get more than the other, you have issues under 726B, under 522C, to where you're now treating creditors in the same class differently. And there, as I jump in and discuss the Milton case in a second, this is an issue that the courts have struggled with. And so what the Ohio court really leaned in on was that, first of all, the language that created the distinction between those two creditors wasn't even codified. Okay, so the bankruptcy law, in looking at it, the court mentioned, if we look at the statute in Ohio, it says these are the exemptions, therefore these are the exemptions. That's exactly like what we see here in Arizona. We have, although there are, just for everyone's information, just to make sure you're aware, there are now two different versions of ARS on the website, right? There's it's some of them say .1 and some of them say version 2, and you can actually go to the old version and the new version, because I think no one knows how long one will apply and if it will. But the actual distinction between those two versions of the law is not in the law. When do you use this one versus when you use that one isn't in the law. So I think we could have courts here, I believe we could have courts here find the same way that Kyle found and just say, look, we have clear exemptions that were passed by the citizens of Arizona. The exemption changes themselves are pretty clear, and those are the new exemptions, because the distinction in the timing of the debt is, first of all, not even codified, and second of all, it's quite vague. And that's where we jump into my second question that I think needs to be answered, which is what about some cases where some of the debt is pre-act, so pre-December, very clearly pre-December 5th, 2022 debt, and some of the debt is very clearly post-December 5th, 2022 debt. And there will be debts that it's not clear, as Brad mentioned, because the language is not really clear in that saving provision. But what if it's really clear, this is definitely debt from before, and then some is definitely debt after, versus a case where maybe all the debt is very clearly pre-act debt. Well, at least the 11th Circuit, because of some states in that circuit, has ruled on this, and that's the In re Middleton case. And Alabama, it's like the In re Middleton case is an Alabama case, but it cites to the 11th Circuit case of National Bank of Mobile, I think, something like that, National Bank of Mobile versus Norris. And they say that the binding law in the Milton case says that the binding law in the 11th Circuit, at least, is that if all the debt is pre-act debt and a bankruptcy debtor files bankruptcy, then the old exemptions would apply. The difference, again, is that in the Alabama law, it was a codified distinction of when the claims accrued. And so that's why I think we have to get past that first question that I just mentioned. What do we do with that saving provision first? But depending on what we do with the saving provision, as we get into the mixed debt versus all pre-act debt, what happens? And I think that the analysis in Middleton, which really is kind of following that Norris case, is sound. It's very likely that that's what happens here in Arizona. So in the bankruptcy context. So actually, before I go to the hypothetical, let me mention one more thing. That First National Bank of Mobile versus Norris case, I could find no cites to that case from any district in the Ninth Circuit or from the Ninth Circuit on that particular issue. However, there's a case called In re Granger. It's a 1985 case. It's a Ninth Circuit case. And the Ninth Circuit speaks very favorably of that ruling. It was on a slightly different issue, because also in that Norris case from the 11th Circuit, the 11th Circuit analyzed the state's ability to pass laws that might arguably conflict a little bit with Section 522 in the Bankruptcy Code. But the exact issue was Alabama wanted to do what Arizona has done, which is we want to have a joint exemption for a homestead. We don't want to allow a married couple to have two homesteads that they stack. And the argument by the debtors to stack it was, well, 522 says that the state can't, although it can opt out of the federal exemptions, it can't it can't be in conflict. And the 11th Circuit in Norris said, no, that, having a joint exemption is perfectly allowable. It doesn't conflict with the bankruptcy exemptions. And so the 9th Circuit has cited on that issue to Norris, and actually went through, interestingly, if you go find this Granger case, they cited to that issue, but also went through all the analysis that Norris did on this particular timing thing as well, in order to basically praise the court for just being very smart, right? And so is that it's all that part is dicta, in my opinion, right? So this is not, I'm not saying that it's binding on the 9th Circuit at all by any stretch of the imagination, but it's pretty persuasive when you see the 9th Circuit just really going out of its way to restate all the findings, even the findings that weren't relevant to its current case, to just praise the court's analysis. Okay, so I think it's likely, right? I think it's actually quite likely that in a case with mixed debt, that our courts here will say new exemptions. In a case with all pre-act debt, possibly old exemptions, but depending on that first question, the uncodified saving provision. Okay,
Ken, I have the practical and maybe an ethical question for you. So you have a client who comes into you, they want to file a bankruptcy case, and all of their debts are old debts that were incurred before the statute became effective.
Yeah.
Do you counsel them to go out and incur a new debt and not pay it? So that
of course not.
I've got mixed debts.
Not, Brad.
Now I get all the new exemptions.
Of course not. As a debt relief agency, I can't advise a client to incur new debt. But as I go through my hypothetical, I'll answer that exact question, because as advisors and as giving legal advice and as counseling our clients, I think we do need to make sure they understand the impact of the law and the impact of the nature of their debt. And so let's look at the hypothetical, because very quickly we'll get right to that exact issue. Debtor files bankruptcy today, okay? Has acquired no new debts. So we'll start with no new debts since December 5th. Now, what does that mean, right? We don't know under that saving provision exactly what might be a new debt. Would defaulting on a debt create after December 5th be the maturing of that debt? I don't know, possibly, right? So it's hard to say. Does the contract have to be signed after December 5th, or do other things have to happen? What about non-contractual debts like torts, things like that, negligence? What if the client gets in a car accident and might owe some money? And it's not an intentional tort, but it's just negligence. I don't know, right? I mean, these are just the questions that there is not an answer to right now. But let's say this debtor has a car owned free and clear worth $12,000, which is above the old exemption amount. Then you're dealing with advising a client on the risk of the new exemptions not necessarily applying. And I think the conservative approach there is to say there is a chance that we only have a $6,000 exemption. I still think you're probably a good, I think Chapter 7 is probably still your best option, but you just need to be aware that you might have to purchase that non-exempt equity back from the estate or surrender your car. Okay, but what if there is some post-December 5th, 2022 debt? Then it's still risky, because we don't know what our courts will do. We don't know if they will follow the Middleton line of reasoning, the Norris line of reasoning. We just don't know that. But I think it becomes more and more of a safer case, a little bit more safe, if there is some post December 5th debt and more post December 5th debt, especially if it's incurred very naturally, which will happen in time, right? In a year, when I'm sitting down with new potential clients. There just will be debt. I'm not going to have to advise them at all. But with cases right now, it makes sense. And the way that we're dealing with it here is we're explaining the risks we're doing this CLE in layman's term for our clients in 15 minutes to say, here's the state of the law, here are the risks. And the courts could decide that if you have some debt from after December 25th of 2022, that maybe you get the new exemptions, and just explain the state of the law without directly saying you need to go get a new credit card or you need to go do this, which we're prohibited from doing under bankruptcy law, as we were found to be debt relief agents, whether you agree with that or not. So what if it's just a really small debt? What if they go borrow $100 from their friend and then file bankruptcy? I don't know, right? This boils down to, can it be determined to be de minimis, and is it done in good faith or bad faith? A lot of these types of questions that come up a lot of times in our jobs, right? And it's why I facetiously say we make the big bucks. All right, so because we have to sometimes ferret out these sticky and unwind these sticky issues. Yeah, so I put in there even, what if it's obtained as pre-bankruptcy planning, like somewhat intentionally? Then I don't know. I don't know under what code provision that creates a cause of action for the creditors, but there, I'm sure, are ways that a creditor could say, yeah, they really should still just have to live with the old exemptions. We talked about non-contractual debt. What if this is an issue that comes up in several of the cases? Well, mixed debt, but none of the new debt files proofs of claim. That's probably an issue for the debtor. So if the debtor only has one new debt, you better be pretty confident that it's a creditor that will file a proof of claim, because I think the trustee and the creditors probably have a pretty good argument that if all the proofs of claim are pre-act, that old exemptions, right? But there are lots of questions that come up with that, and that Middleton case goes through them. Just how tricky it is to administer a case, even for the trustee, if the trustee doesn't know the nature of the debt. The trustee incurs administrative expenses, hiring an attorney to start to research things, and then finds out that all the debt, the most of the debt is post-act debt, and just spent money for no reason. And it's not always easy to tell when it's pre-act or post-act. And the Middleton case really dives deep into a lot of those sticky and tricky issues that, if we had another hour, would be really fun to go through and talk about, but instead go read the Middleton case. And did any questions come up that I should try to quickly answer before we
Jim Kahn mentioned that the debtor can file their own proof of claim.
Yeah.
For that.
Yeah. Thanks, Jim. Yeah, it's a really good point. And
the other question is from John Skiva. He says, have any of the trustees provided an opinion as to whether or not they'll raise objections?
So super informally, we've heard from a couple of them that they don't plan to, but it's that could change, right? No one's provided me a written promise that they won't object, or that by hiring counsel they may be advised differently on some of these issues. So I think where you're dealing with a large probably homestead, right? You're dealing with a large difference to the estate between pre and post act exemptions. That's where at some point there will be some litigation, and we'll get a bankruptcy court ruling, and possibly then a BAP or district court or even Ninth Circuit court ruling at some point. So
and Alan Slot says, how will trustees handle the deadline to object to exemption, 30 days after the meeting of creditors?
Yeah, so I mean, Alan, if they want to preserve the exemption, they just have to file it and the exemption and then deal with it. So here's what we're doing in practice right now is we are claiming the higher exemptions, but we're being really careful if we need the exemption because the asset's worth that much. And we're kind of, I think, dipping our toe in the water to see if trustees object to sort of preserve their rights in case the asset is worth more. I don't think we'll see trustees objecting if the asset's worth less than the old exemption would have protected. I don't think, but we might. And that's where we would see, well, these trustees are going to try to preserve that objection in case the asset's worth a little bit more than the old exemptions. So,
Scott Hyder also reminds us that the Supreme Court held it's not improper for a debt relief agent to inform a client on what the consequences of incurring new debt will be.
yeah, I mean, I think we have First Amendment rights to give legal advice and explain impact and consequences and things like that without directly advising or counseling to go incur debt. So thanks, Scott. That's a great point. All right, so let me at least pop up here Brad's contact info for those of you who maybe want to screenshot it or write it down at Engelman Berger. And I didn't confirm with Brad, but I'm sure he's open to emails if you have additional questions or just need a good creditors' rights attorney. And then there's my contact information. And as I mentioned, always happy to talk about these issues or other issues around consumer debtors. So, and then I know ACBC wants the disclaimer up here before we end the recording, but we can stay on for a few minutes and answer additional questions if any of you are interested in staying on and doing that.
And
thanks, everybody.
If everyone will note that I've posted the CLE certificate a couple of times. If you are on here with a phone number or just a generic name like RC Office, I will not have your name to be able to verify to the state bar that you were present. So either change the name on your Zoom or email me at admin@acbcforum.org with your name. Thank you. Go ahead, Ken.
Yeah, thanks. I don't see any new questions. I saw a comment by Ross. Thanks, Ross, for putting that. Ross Miners put in there that he had a 341 meeting recently where the trustee seemed to just be going with the new exemptions. So at least for now. And that's kind of what we've seen so far, but it's really early, right? We're only a few weeks into this. So it's hard to
on a personal note, what I'm doing with my clients is making sure they're under the old exemptions, but claiming the new exemptions. That way, if I get pushback, I have a fallback.
Yep. I think that's going to be pretty common. Best case, for those of you who do consumer bankruptcy and use best case, has now updated and put the new exemptions in as the Arizona exemption. So I think we're going to just see those a lot on Schedule C. So, but be cautious, be wary of the risks of doing that. So, and then another comment, Morgan said, Dina Anderson actually brought one of Ken's cases up on the new exemptions and whether they would be amended or if she needed to file an objection. Oh, interesting. Yeah. Okay. I didn't do that 341, so I didn't hear that, but thanks, Morgan. So, one of my partner attorneys must have been doing that 341 meeting. So
now it was mentioned that would ACBC do a follow-up on this when we get more clarification. We keep track of what's going on. We have a very active amicus group too. Just so you know, April Maxwell is our chair of that group. In fact, April's probably the group for the most part. Anyway, as we see that things have gotten solidified, codified enough that we can bring you something, then we will. Do note, though, that the majority of our programs are member only. We just do these massive email or massive CLE programs when it is really affects and reflects on all of our stakeholders in this community.
yeah, absolutely. Let me just point out again that David Hammeroff and the Creditors Bar Association is at least members of it. Is, I don't know if it's officially sponsored by ACBA, but is doing a CLE on Thursday. So he put info@arizonacreditorbar.org if you want to get the information for that. And then he also asked me just to emphasize one more time, and I think it is worth emphasizing one more time, how big the change is on the garnishment on the 30 times. It used to be 30 times federal minimum wage. Now it's 60 times applicable federal, state, or local, whatever is the highest, which would be really high, like in Flagstaff, for example. Someone posted the Flagstaff court website. So it's a big change. It's not even, it's more than even doubling, because Arizona's minimum wage is pretty high. We're one of the highest minimum wages in the country now, with that inflation indexing. So yeah, pay attention to that. It just really takes away that right for creditors as this, you know, if this becomes effective, if it's held to be effective to whatever debts it is held to be effective against, makes a big difference on wage garnishment, really big difference. So I think I covered everything. So thanks, everybody.
Okay, well, thank you very much for attending. We hope that you appreciated the subject matter, even though we don't have any, hey, guess this is the final answer to your question. It's just a whole bunch of questions. Please feel free to share the video. As I said, we'll get it posted to the YouTube channel in a couple of days. So my thanks to both Ken and to Brad. Ken has been a absolutely exemplary hero for us in the last year, doing both the homestead stuff and then the legislative stuff. So Ken, double, triple applause to you. Thank you.
Thank you. My pleasure.
Thanks
Brad.
everyone.
Bye.
Hey, Scott had asked a question to Ken.